Happy Tuesday! It's time for coffee and cursey words. I've brought both the coffee and the cursey words. Today we're talking about regret. That's really what we're talking about today. We're going to talk about regret. We're going to talk about how society views victims. We're going to talk about contracts and creators, and maybe, just maybe, a hostile work environment or two. It's interesting to me the parallels that I think you may see between the Haley Page JLM trademark name lawsuit and the David Dobrik, Jason Nash, Seth incident. So we're talking about both of those things today, and we have a ruling on court of public opinion. As always, we will have timestamps down below for the replay crew if you want to just get into it, because we always do a little housekeeping on Tuesday. So we should just get started because it's here. You're here. I'm here. We're all here. Let's roll. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I love that song so much. I'm going to have one done for Court of Public Opinion. I just really want to. I hope everything is well with you this lovely Tuesday. It's starting to be spring around here. Like flowers are starting to pop up. The animal noises, like the country quiet noises are coming back, like all the little critter noises and the frogs and the owls, and it's kind of nice. I don't know. I'm kind of feeling it. I'm a vibe today. We're having a whole situation over here today. We're doing it. We're doing it all. Let me know in the chat what you're drinking. I'm letting you know that today we're going to talk about Haley Page first, then we're going to talk about David Dobrik, and then we're going to answer questions. I feel like based on what I've seen in comments and what I've seen on Twitter, that there's a lot of questions around the David Dobrik, Jason Nash, Seth conversation, and we can absolutely get to all of those. So I want to make sure that I get it second so that we can go right into questions. But there's a lot to be said and to learn from the Haley Page JLM lawsuit. I love seeing what you guys are drinking. I love it. I love it. I love it. Good morning. I know this isn't finding everyone in the morning. This is finding you wherever you are. Lauren Glover, happy birthday. And if you're in the text crew, birthday messages went out. I get to them most days. Some days I miss them. So if I missed your birthday on Sunday, I am sorry. We had a birthday in this house. If you follow me on Instagram, you will have seen me talking about it. My son, my oldest, turned 13. I have all of the feelings about it. I'm not mentally prepared. Like, I am a fairly strong human. What I'm not prepared for is my son to be 13. And it's not because he's not amazing. Like, as far as 13-year-olds go, my kid's pretty great. He's savage with his sense of humor, but he's a great kid. And I dig him. He is smart and he is challenging and he is funny. And he's becoming more of a ginger as like time goes on. He was really red when he was born, and now he's getting really red again. But like, I'm not emotionally prepared for him being like, I can't wait to get a car. And like, when he turned 13, I was like, you're able to be on social media. You're able to have your Gmail account. You're able to have a Discord account. You're able to have these accounts. I'm like, let's talk about what you want. And he's like, I really just want my Gmail and my Discord to talk to my friends. And I want to find a better Call of Duty team because the kids I play with in COD Warzone are rage quitters. And I can't. I need people who are more dedicated. I'm like, yep, that's my kid. I need people who are more dedicated. And Nikki P, I see that you and I are having the same experience. It's so wild. It makes me feel old. It makes me feel unprepared to like have a kid that drives. I don't know. He was premature, my oldest, which is something I absolutely am not afraid to share. I had a lot of shame around it because I had such health issues in labor and delivery with him and sudden onset preeclampsia and all the things. And I had a lot of shame around like, oh my God, my body's just not working for me. And to see how much he's grown is just because his birth, still having a preemie is a specific and kind of traumatic event for parents. And it's something that sticks with you. And so just being like, wow, we got to 13. Like the first year was like, keep him safe, keep us safe. And then you start to grow. And now it's like, okay, there's a whole other world to keep him safe from that I have way less control over. And now it's teaching him to keep himself safe. And covering the stuff going on with David Dobrik has triggered me about it, because teaching him to keep himself safe in the age of social media, and when you see how toxic some of these friend groups can be because of A, the environment of it, B, wanting to be YouTube famous, like all the things, it's hit me differently. And that's not to say I have tremendous judgment towards David Dobrik. I have judgment towards a lot of this behavior for sure. I don't know David Dobrik as a human. I also have seen people do things they wouldn't normally do because it's going to be on YouTube. It's going to get 10 million views. It's going to do whatever. And so that is something I think that's more important to talk about, is that situation. And that's one of the things that hits me as a parent of a teen. How do we teach our kids to protect themselves in, like, not just from predators on the internet, but from their friends who may push them to do or say things that they don't want to do or say? How do we do that? And that's what we're going to talk about. So for sure. Hello, Mariah. Welcome to the channel. If you guys aren't channel members, you can go ahead and do that. It is lawnerdzunite.com or the join button on your channel. I know there have been issues with joining channels on YouTube. I've been having issues too. So hopefully watch lawnerdzunite.com will get you there. If it doesn't, YouTube should do it, but know that there can be issues on YouTube. And then you get to do the pre-party chat and help direct content and be on the members only live streams and all of those stay up. So when you become a member, if you want to go watch past members only live streams, those are all there for you. So let's jump into the court of public opinion first, and then right into Haley Page, because I feel like I'm going to talk a lot today and I want to chat, but there are going to be rants. There's just going to be rants. And we should just get to court of public opinion so we can get on to the ranty things. I love that too. So this week's court of public opinion, I asked y'all where you brush your teeth, and you saw that my family had all of the thoughts about this. If you were not on that stream, the end of the stream, I'm sure it's timestamped when my family came in and joined the conversation, but that there were a lot of thoughts about it. Like the fam had thoughts about brushing your teeth in the shower. And my son particularly was like, well, I can see why it would make sense, but I don't know if I want to leave the toothbrush in there, but I don't know if I want to spit toothpaste while I'm in the shower. Like, I don't know what I want to do. But brushing your teeth at the sink, smashed. And I realized this is maybe more of a particularly US thing, because others are like, no, in Korea and Japan, we have kind of more wet room bathrooms, or the sink and the shower are all just kind of there. Some places it's like, no, I don't want the shower water in my mouth. I prefer the sink water because it's filtered differently. So I realize every time we ask these, what I love about having such international law nerds is that we get to learn about the mundane kind of day-to-day things you might not know just visiting a country. The things that are more specific and more detailed about what it is really like to live outside your own experience. And that's why I love Court of Public Opinion so much. I think it also gives us a good chance to have a laugh, have some fun together, and just talk. So this is the YouTube results in the poll. in this group, we had a 15% that brushes their teeth in the shower, which is great. 85% at the sink. We've outstripped the average. And I think it's because y'all have other shit to do. And you're just like, no, I have other stuff. I have other stuff to do. I have other stuff to do. Donald Duck, I'm sorry that is your experience. That is a trauma on top of trauma. We're going to be talking about trauma today, but don't worry. I'm going to give you guys a warning before we start talking about trauma more, because I think that that's always helpful. So we will talk about that, because people who have trauma and have traumatic experiences and PTSD can also be triggered by just talking about that. So we're going to give a heads up. We're not going to do that yet. I do, as a dental assistant, I also floss and mouthwash in the shower too. The shower pressure helps loosen tartar and gets junk out of your teeth easier. It's better than a water pick. I love that feedback. I love that feedback. So people are like, I'm going to try it. I might try it. I might go ahead and try it. I love the comments that you guys share. And some people are like, no, I don't want hot water in my mouth. Also fair. Anna Pie said, I do both. I'm a dentist. I keep a Quip Sonic toothbrush in the shower for days I'm running late, and my Sonicare that I regularly use at the sink. We use Sonicares too over at this house. And on the Twitters, it was about the same, which I love that across our audience, the ratios are about the same. And I know it's different people responding on Twitter a lot of the time than responding on the poll on YouTube. It's just who sees it, because YouTube has a different and larger following than my Twitter, but I love that we get to talk about both. So 85.9 to 14% at the sink, but sitting on my tub because I get dizzy standing. Fair enough. I've never heard of such a thing. I love that we have brought it to others. We have brought it to others, and there are articles about it. Look, the ADA has an official position about it. The American Dental Association has an official stance on brushing your teeth in the shower versus the sink. And their stance was, I mean, brushing your teeth twice a day is what you need to do. And that there was no harm to brushing it in the shower. So that's what it is. The only questions about the shower were removing your toothbrush from the shower and whether there could be things growing on your toothbrush if the shower stays moist and things like that. But I imagine everybody kind of monitors their own toothbrush. Like, I trust y'all to keep your toothbrushes from getting nasty. Like, I trust you. I trust you. So we can do Haley Page two ways. We can either talk about what she said on social media, or we can talk about the ruling first and then use the ruling to look at what she said about it on social media. I'm going to do a TLDR. I want you to tell me in the chat, should we just look at the ruling first and then look at what she said about it on social, or vice versa? But let's do a quick TLDR. By the way, too long, didn't read. I have a whole other video on this. We're going to do the abridged version of what the fuck this case is even about. JLM Couture versus Haley Page. Haley Page is a wedding dress designer. You may know her from Say Yes to the Dress. She separated from her employer, JLM Couture. She was a designer for them. It seems that she has been a designer for them for a substantial period of time. Their statements in this case and in this lawsuit are along the lines of like, yeah, we built you. Like, you were on Say Yes to the Dress because of your connection with us. We built your social media because of your connection with us. And now the fight is on as this employment relationship is breaking up over her or their Instagram account, TikTok account, Pinterest account, and other social media accounts. And that's really the fight at the heart of this case, is the use of social media accounts, because JLM Couture had an employment contract with Haley Page. Part of that employment contract included her selling the rights to the name Haley Page. So you can't have a @Miss Haley Page handled Instagram account if @Miss Haley Page is the intellectual property of your employer, JLM Couture. At the beginning of this case, JLM filed suit against Haley Page to solidify their intellectual property rights and to take back the social media accounts, TikTok, Pinterest, Instagram. The Instagram account has over 1 million followers. It's a very engaged account. Part of what JLM was complaining of in the complaint was that Hailey was starting to promote other brands, like actually doing brand deals on the Instagram account, but it's the business Instagram account. And JLM said, well, this is our business Instagram account, even though the account handle is Miss Hailey Page. You can't just do brand deals for like salad dressing or whatever, because it might intimate a brand relationship with this other brand. And that's like, this is our brand account. You can't just go put up other shit on it. Like, you can't do that. And in the videos where I talked about this, and in the podcast episode or the Emily Show episode where I talked about this, we talked about what you need to know in advance. We talked about selling the rights to your name and the fact that that's something that you actually can do and was done here. There's no argument that the rights to the name were sold. There's no argument that the contract's invalid. The argument is, does the contract extend to social media handles? That's really the heart of this case. JLM Couture owns trademarks for Miss Hailey Page, Hailey Page, Hailey Page, and a bunch of other stuff in connection with the bridal industry. And they're saying that extends to her Instagram account. She's saying that's her personal account, and it doesn't. It's not contested that that account was started during her employment with JLM. And this is something that all creatives need to know, that what you create while you are an employee can become the intellectual property of your employer. See Bratz Dolls and others. There are some types of industries, tech being one of them, that will carve out particular exceptions. But even if you write a book about something you've done in your time that you're employed, you generally have to go to your employer and get their approval to release it, depending on the nature of your employment. So this is something, when we talk about what creatives need to know who owns the rights to the shit that they're creating. And of course, JLM's going to argue, without us, you wouldn't have had the opportunity to become Hailey Page, the social media personality, versus Hailey Page, the human who's going through all of this. And Hailey Page argues, this is a mean company and they're being mean and bad to me, and I don't like it. But it will be interesting to see how the law takes the trademark rights here to Miss Hailey Page. Can it be extended to a personal Twitter account? Or is that so connected to the trademark rights that you can't have that Twitter handle? Now, I'll tell you what, on Instagram, on Facebook, whatever, you generally can't have, like, at Instagram expert for you as your handle. That's not your intellectual property. That's Instagram's. Whether they enforce it or not is a whole side issue. But you can't use other people's intellectual property that way if it's protected that way. So JLM sought a temporary restraining order that has now become a preliminary injunction, meaning, hey, you can't do that. Stop right there. Thank you very much. Look, this is an injunction. There's going to be so many stop-related songs. We're going to try to rein it in, but it's a preliminary injunction. So the court granted JLM's preliminary injunction, stopping Hailey Page from using the shit she wants to use. Her name, her Instagram, her tickety-tockety, her Pinterest, the things. She can't do that. So she's been posting on All That Glitters, and we're going to talk about her statement, and we're going to talk about JLM's statement. They released a statement on Instagram this morning. I'm going to read you the judge's conclusion, and then we'll back up to some of the reasoning behind it, because the conclusion is really like, tell me the thing I need to know, Emily. Yes, here's the thing you need to know. Let's just pull it up so we can all do it together. Here's the judge's ruling. This is a very long and clear ruling. This judge, y'all, look, when I say federal judges don't play, this judge is kind of having none of it. And it basically reads like, you contracted for that. I'm sorry that you regret it now. No, I'm not sorry that you regret it now. Sorry, not sorry. You regret it now, but that's not like a legal valid excuse to invalidate a contract. So while Hailey Page may be winning the war of sympathy on social media, this judge we're just going to make a note. We're going to say this a lot today. What you may feel is equitable and just and moral, and what the law says are different things. And oftentimes, very different things. So in your gut, the feeling might be, yuck, this company is just using her name. But the law says that shit you can sell, and you can sell it, so you sold it. And if you sold it, you can't just go say, hey, I didn't want to sell that. Can we just undo that? Like, not buy it back. Can we just undo that? And even if she wanted to buy it back, they're not obligated to sell it back. We see this with musicians too. We see this with other types of creatives too. And the reason we're talking about this, partly, one, because it's interesting. And two, we're going to see more litigation over social media accounts. But three, if you are creative, I hope that every time you read a contract, this case is in your mind. You're like, but I'm not a wedding dress designer. Right. But remember, okay, I said I was getting into it. Now I'm ranting. But remember when Christine Snaps was on the channel and shared that after she had a TikTok video go viral that exploded her social medias, a company popped out of the woodwork and was going to help her like track down all the copyright claims. Yeah, but to do that, they made her transfer the copyrights in her viral video to them. She was able to get it back, but she didn't know, right? You're not always aware that, oh, what does this mean? What rights am I transferring? And it's something to be on the lookout for, because again, viral videos don't come with a rule book. Blue check marks don't come with a rule book. Verified status doesn't come with a rule book, and maybe it should. Haley Page Gutman. Conclusion. For the foregoing reasons, also, the federal court in New York doesn't use page numbers. It's so confusing to me. Look, when I say courts all do things differently, courts all do things differently. This is a New York case. For the foregoing reasons, plaintiff's motion for preliminary injunction is granted to the following extent. During the pendency of this action, so until the end of this lawsuit, Ms. Gutman, along with her peeps, and all other persons who are in active concert or participation with her, all the peeps, are enjoined. Stop, collaborate, and listen. I sit back with a brand new invention. Are stopped from doing any of the following shit. Okay, look, I am reading into what this says to explain it. I'm translating it live from legal to muggle. Plus cursey words. Making any changes to any of the social media accounts listed in Addendum 1 here too. Addendum 1, by the way, we're just, so we all know what we're talking about. These are all the accounts. She can't do shit. She cannot touch them. She cannot change them. She has to turn over access to them. Cannot touch it. These are all of the social media accounts. That's a lot. The big ones are the Miss Haley Page Instagram account with 1 million followers. Facebook, Haley Page / Haley Page Bridal. Pinterest, Haley Page / Haley Page JLM. Pinterest, Miss Haley Page. So I imagine Haley Page is like, Miss Haley Page is mine. Haley Page JLM is theirs. YouTube, Miss Haley Page. Imagine contracting your YouTube channel. Twitter, Haley Page JLM. Instagram, Blush by Haley Page. Facebook, Blush by Haley Page. These are all sub-brands. Instagram, Haley Page Occasion, sub-brand. Facebook, HP Occasions. Excuse me. Twitter, Jim H Occasions, which was a brand she was designing for, which was laid out in the complaint, and I talk about in the other video. Another Instagram, La Petite Haley Page. Facebook of the same. Instagram of Holy Matrimony. Facebook of the same, and TikTok of Miss Haley Page. All of the shit. That's Addendum 1. All of the social media accounts. Including but not limited to changing the names and handles, posting any new content, deleting or altering any content, tagging to other posts, users, accounts, transferring any such accounts or rights to any such accounts to any person except to JLM, communicating with third parties through same for commercial purposes. Through same means through your peeps. So you can't make brand deals. You can't post, you can't delete, you can't do anything without the express written permission of plaintiff JLM's chief executive officer, JLM, Joseph L. Murphy. Utilizing or taking action to gain exclusive control over any of the JLM HP social media accounts, trying to change passwords, trying to change access, trying to lock them out, can't do it. Breaching the employment contract, hey, you're still under an employment contract. You can't breach the contract you signed by doing these things. Using or authorizing others to use any of this intellectual property, which means you can't license your name. You can't design under your name. You can't do anything under the name Haley Page, Haley Page Gutman, Haley Gutman, Haley Page, or any derivative thereof. Meaning Miss HP is not going to work. Miss HG, not going to work. And then they say, including Miss Haley Page. Or using any confusingly similar marks or names in trade or commerce. That's going to include social media. So nothing confusingly similar. Nothing confusingly similar to her name. It's going to have to be something different. Without express written permission again. Once again, if this express written permission route were going to work, we wouldn't all be in federal court with this thing. This would have resolved. They would have all gone their separate ways. Because they can't agree is why we're in court. So I don't think there's going to be express written permission about anything. Directly or indirectly engaging in, being associated with, whether as an officer, director, shareholder, other shit, any person, organization, or enterprises which engages in the design, manufacture, marketing, or sale of bridal apparel, including bridesmaids, mother of the bride, and flower girls apparel or related items, bridal accessories and related items, evening wear and related items, and any other category of goods designed, manufactured, marketed, licensed, or sold by JLM. That might not have felt huge as I read it, but she cannot indirectly design for, be associated with, consult with, advise, be employed by, be a contractor of, be an agent of. She cannot engage in the bridal industry in any way. Any item manufactured, marketed, licensed, or sold by JLM. That's a lot of stuff. That's the non-compete coming out there. Using or authorizing others to use any designs, licensing. Designs is any of her shit that she has drawn, designed, media accounts, what have you. For any of the trademarks, using or authorizing others to use any of the designer's names, trademarks, or confusingly similar terms, names, symbols, or device, or any combination thereof in commerce in connection with any goods or services. Any goods or services, including to endorse, advertise, or promote the products and services of herself or others directly or indirectly, including but not limited to on social media and television or media appearances without the express written permission of Joseph L. Murphy from JLM. Let's take a minute on that one. Using or authorizing use, that means allowing someone else to say, oh, you know, Haley Page is a Fenty partner. Haley Page is partnered with whatever brand deal. Can't allow anyone to use it. Any of the designers' names, trademarks, or confusingly similar name or symbol. This is why, by the way, Prince changed his name to a symbol. Not because he was a wedding dress designer. This type of contract dispute is why Prince became the artist formerly known as Prince. Are we going to see FKA HP? I don't even think she can, because HP also might indicate Harry Potter. I don't know what we're going to see. We're going to get into her Instagram in a minute and talk about it. But she cannot use her name in connection with any goods or services, including endorsing or advertising. No brand deals, no consulting, no nothing until this lawsuit is over, which puts her in a terrible position to continue to write out this lawsuit. This puts a tremendous amount of pressure, I'm sure, on her side to settle, or rage. Rage is also an option. There could just be rage. And it's like, fine, we will fight this till I fucking die. I will die on this lawsuit. Done. To the extent not previously delivered, if you don't already have that shit, within 24 hours of the entry of this memorandum, which means by now, because this came out March 4th, defendant Gutman shall deliver to plaintiff's attorneys the current login credentials, including username and passwords for the accounts defined. So all the accounts that we read, give them all the information and let them log in. And then it talks about the condition. There is a $200,000 maintenance posting to secure the payment and cost of damages that may be suffered or sustained by any party who is wrongfully restrained. No additional bond is needed. Preliminary injunction will remain in full force and effect until the final judgment in this action is entered. This means, in sum, that the court found substantial likelihood that JLM can succeed on this case. I'm going to tell you some of the highlights, and then we'll go back through and pull this up if there's more questions. Some of the highlights from the court was that Ms. Gutman, quote, contracted away any right to monetize the Haley Page trademarks and voluntarily, knowingly, and intelligently, in exchange for consideration, monies, waived her rights to use the designer's name for commercial purposes without JLM's permission. She sold that shit. The court also found that Ms. Gutman's reading of her contract to try to narrow that prohibition is, quote, conveniently but illogically ignoring other provisions and was inconsistent with the plain language of the contract. I read out the contract in both the Emily Show and a live stream, and those are tagged on the channel if you just search Haley Page and their timestamps. I read the contract, and it very clearly said that she was selling it. The amount of money she sold it for is blocked out. The court also said that the Instagram account was developed as part of her employment and it was commensurate with her position, i.e., it's work-related. There was testimony. The court found the testimony of Mr. Murphy to be credible, that the marketing strategy included these social media accounts, that the court also said she had, here, let me just pull it up. Let me just pull it up as I'm talking through it. Let's just pull it up. That she had talked to an attorney. Now, in her Haley Page's first Instagram account, first Instagram post on this, she said, I never had a lawyer review this. I didn't know what I was in for. But in this, the judge found, and there was testimony, that Haley told JLM she had a lawyer review this and that there were rounds of negotiation. It wasn't just like, hey, boo-boo, we gonna make you famous, sign right here. There were rounds of negotiations. This was more than a sign the line. And when the court went through their findings of fact, this is the court determining based on evidence and documents that have been entered into the record that these are the facts. The court says the facts are this. The facts that were interesting to me were that, in the contract, Haley Page was contracting to perform duties, including the exclusive rights to use her name, Haley Page, and Haley and Page and Haley Page Gutman and Haley Gutman and Haley Page and any derivative thereof. That in exchange for the assignment to the company of the designer's name and trademarks, JLM agreed to pay her consideration in addition to her base pay. So she got paid for those rights to be transferred. We just don't know how much. JLM agreed to pay Ms. Gutman as consideration in addition to her base pay and additional sales volume related compensation, and for 10 years following the termination of her employment with the company, a further percentage of net revenues derived from the sale of goods under her name. So when she leaves the company, she will still get a percentage of goods for 10 years after she leaves because they're going to continue using her name. So she is continuing to get paid. Now, do you think, well, she sold it, so too bad. And two, well, she's still getting paid for the sale. It's ongoing. She got paid once and she's continuing to make money for 10 years after she terminates employment. Does that change how you feel about this? Knowing that, because that I did not see as clearly in that contract that there is going to be continued payment, but we didn't go over the amended contracts, and there are amended contracts. A percentage of net revenues derived from the sale of the designer's goods under the name and trademarks for 10 years after separation. So they separated in 2019, so through 2029. The parties engaged, and this is what we didn't know, this is from testimony. The parties engaged in rounds of negotiations over the terms of the contract, during which Ms. Gutman referenced a Kenneth Poole example and asked to add perpetuity language. Ms. Gutman represented to plaintiff during negotiations that she had an attorney review the contract during the negotiations, a statement which she now claims was untrue. The court, I don't think, is persuaded. On September 12, 2011, Gutman signed a trademark registration acknowledgement confirming that she had transferred all trademark rights in the name. So this wasn't like a whoopsie, I didn't think I was signing over those rights. You buried it in language. When we pulled up that contract, it was headlined out. This is what you're getting paid. This is what you're selling. And then she had to take the steps further to sign those over and say, yes, you're registering the trademarks under my name. Here are relevant contract provisions. The contract provisions material to this preliminary injunction read in pertinent part. The relevant shit is the duties, the covenant not to compete, which is what we're seeing in the you can't go work elsewhere in bridal and you can't use our intellectual property, damages in case of breach. And those have been discussed. This section is the one that we pulled up and went over. The heading in the contract says exclusive right to designer name. This isn't buried. She might regret it deeply, but it was not buried. Not buried. So the employee hereby grants to the company the exclusive worldwide right and license to use her name, Haley Page Gutman, Haley Gutman, Haley Page, or any derivative thereof in connection with the design, manufacture, marketing, and or sale of bridal clothing, bridal accessories, and related bridal and wedding items, including any and all goodwill associated therewith throughout the term, including any extension of term, plus a 2-year period following the term or any extension thereof, provided the employee has substantially participated in the design and creation of such clothing related. And then it goes on to the trademark rights where she releases them to be trademarks. And that's where the in perpetuity forever comes in. Then it talks more about designs and intellectual property. Since we've already gone on over this in other videos, I'm not going to go over it ad nauseum because we've heard the court's ruling, which is this is what you can't do. Again, that ruling in this preliminary injunction reads very much the way I imagine a ruling would read if JLM wins this lawsuit. And the court, in granting this injunction, which is a pretty steep step, indicates that the court believes there is a substantial likelihood that JLM will win this because the contract language is clear. And at the end of the day, this is a contract dispute. It talks about in 2004, prior to contracting with plaintiff, defendant opened a Facebook under the name Haley Page, as well as a Twitter and LinkedIn using similar terms. Miss Haley Page is a term of endearment for defendant used by her mother. On April 6, 2012, while employed by plaintiff, defendant opened an Instagram account. Defendant proffers that when she created the account, her given name was already taken by another person, so she went with Miss My Name, creating the Instagram handle Miss Haley Page. Defendant opened a Pinterest and TikTok under Miss Haley Page after becoming an employee. So that's the timing. These accounts were created at the time when she was employed, and because her employment included the promotion of her and the sale of her name, that those things may have become property of the employer. This goes over what we saw in Haley Page's response, that she used the account to build her personal brand, really, and to show her work as a designer, to kind of build her own persona within being a JLM designer. She discussed marketing strategy with them, and on and on and on. There don't seem to be a lot of disagreements with the fact, other than the lawyer negotiating and the fact that this was a back and forth. It wasn't just a sign the contract and away we go. It was actually a negotiated agreement. The court reading into that she understood and now later regrets it, which is, again, not a legal standard for getting out of a contract. They talk about plaintiff working with a social media director and strategist. They talk about Haley Page working with the company's social media team to balance the page and things like that. So this being a work asset. They go on with it. Haley Page said, no, this was very much my personal account, not my work account. The court at this point in time disagrees. In July 2020, Gutman entered into an influencer agreement deal with Chosen Foods, a salad dressing company. The evidence showed that the term influencer refers to the holder of a social media account that is viewed by a large enough number of other social media accounts that the holder can feature the goods or services of another person or entity in the account's content in exchange for payment. It's a great definition of influencer. Mega influencers operate their accounts in a business manner. Under her contract with Chosen Foods, Ms. Gutman received compensation in exchange for promoting the products on the account. Gutman did, in fact, post photos promoting Chosen Foods to the account. She also provided Chosen Foods with analytics for the account. Then it gets into what we know what analytics are, but it gets into what analytics are. Gutman used the account to promote nutritional supplement of a third company, Optimum Way. Defendant is also shown on the Optimum Way website in an influencer capacity. So now this is kind of going against what they're finding that employment contract holds. What else did the court find particular? Those are the big ones for me. Citing the contract, its registered trademarks, and plaintiff's conduct before and after the issuance of TRO. Plaintiff now seeks preliminary injunctive relief, and it gets into what the company is looking for, and that is what the court ordered. What they are looking for is essentially what the court gave them at the end of this. There are a few that were not given, but they were combined, if you will. Likelihood of success on the merits of the breach of contract claim. This is why strategically seeking an injunction can backfire, because now what you have is the court saying, this looks pretty good for the person suing. The parties dispute the meaning of the provisions of the contract describing defendant's duties and scope of its provisions, transferring the rights of the use of her name. Quote, whether the language of a contract is unambiguous, and if so, what construction is proper, are legal questions. What's the law? What does it mean? And that's where this is at. What does the contract say and what does it mean? And the law tends to default to plain meaning, because that way it's unambiguous and clear. This means this, not that. And if this means this, then who wins? Contract language is not ambiguous if it has, quote, a definite and precise meaning, unattended by danger of misconception in the purport of the contract itself. Is that clear and unambiguous to anyone? Maybe not. Lawyer speak. But if it can be interpreted the one way and that's the way that's most natural without having to reach, then that's what the fuck it means. As an initial matter, the parties dispute whether Gutman remains bound by the provisions of the contract that applied during its term in light of the defendant's December 17th, 2020 publicly announced resignation. The contract defines its term as commencing on the date of full execution and extending until April 1st, 2016, and further provides that the term can be extended for up to 6 years. Plaintiff has invoked the extension provisions. The term currently runs through August 1st, 2022. Here's what happened with that. In the contract extension, it said that JLM could extend the contract. The company could extend the contract. Now, these types of contract provisions I do not like, but they are in music industry contracts and other contracts where the business can say, we're extending your contract, and the individual can't really say, nah, I want to go ahead and not do that. It's like, well, we have an option to extend, so we're going to go ahead and extend it. It's not a mutual option to extend. So you can see and understand where the frustration is for Haley Page in this. Even though she signed this agreement, you can understand the frustration, just like Kanye's mad at his contracts with his recording industry. Should contracts like this be allowed? That's a whole different question. Right now, contracts like this are allowed, and she signed one. But that's where that feeling of but that feels wrong, right, but legal. The contract defines its term. We talked about that. So she's still bound by this contract until August 1st, 2022, and then for a period of time after that. The contract is thus for a definitive term and includes no provision empowering Ms. Gutman to terminate it unilaterally. She can't say, peace out, bitches, I'm done with this. No provision. If you're If you're in a contract, any kind of contract, make sure that there's a way for each party to get out if necessary. That's something that needs to be discussed. If you are signing a contract, make sure you know where your escape hatch is. Look for the exit in your agreement, even if it's meant to be forever, even if it's a marriage contract. Look for the exit. I mean, I've been married for fuck ever. It's great, but know what the exit is. And if you are curious about what that might look like, I have content about the Kim and Kanye divorce, talking about their very grown up divorce that's happening right now. Look for the exit. Look for the exit. Ms. Gutman cannot terminate it unilaterally. And this is where a lot of the yuck comes in, right? It's like, right, but that feels gross. Right, but it's legal. Right, but it feels gross. Right, but they agreed for money. And once you agree for money, there's not much you can do when you later are like, yuck, it feels gross. Unfortunately. Or fortunately, because imagine you signed the contract with somebody and they were like, hey, I can't unilaterally get out of this contract, but I'm going to go ahead and go. You're like, that's not what we said. Like we put in this money, and this is the company perspective would be, but we invested in building you so that we could all rise together. And we did that because we knew that there was a period of time that we could have you. It's like, what if you bought your house? Let's put this in another way. You bought your house, your dream house, almost. And you're like, awesome, my dream house, but I'm going to add outdoor living and a pool and an archery range. I'm not just talking about me, maybe a little bit. And all these other, I'm going to add the things that make it my dream house. I'm going to soundproof shit. It's going to be perfect. And you spend your time and your money and your energy building it out because it's yours. You bought it. And you're modifying it and sinking your money into it because that's what you choose to do. And then the builder comes back later and is like, so yeah, what we're not going to do is have you keep that house. We'd like it back now, please. It's like, I paid you for the thing that I have. And then I invested a fuck ton of money into it to make it the thing that I have. You can't just come and take it back. That's not how any of this works. We have a contract. You're not taking my house. It's the same thing. We're just talking about a person. But she sold the rights to her name and she entered this employment contract, and they invested in her to build her brand, to build their brand together, because they knew, hey, we have these contract terms. It's worth our investment into you to put you on Say Yes to the Dress and to grow you as a brand and to grow your social media, to get you to 1 million subs, to get you verified, all of this, because it builds your profile, builds our profile together. So we invest in it together because we have this contract that you're in. So you can't unilaterally peace out. Whether you agree that that is right or wrong or good or bad, it was agreed to. The court's analysis of the contract in relation to use of defendant's name begins with Section 10A, which grants plaintiff company the exclusive worldwide right and license to use the names. This provision unambiguously transfers to plaintiff the exclusive right to use the name Haley Page and any derivatives in connection with bridal goods, and defendant substantially participated in designing or creating during her employment until August 1st, 2022, and for 2 years thereafter. The term designer's name also unambiguously encompasses Miss Haley Page at Miss Haley Page, which are derivatives. Defendant's conclusory argument, that means you jump into conclusions there, that the designer's name only includes the variations listed in Section 10, reads the term any derivative out of the contract provision. Well, there it is. I mean, that's a court just being like, no, that's not what it says. It says what it says. I said what I said. A derivative is something based on another source. I said what I said. That's derivative. The defendant's contractual transfer to plaintiff of the right to use and control and use and the use of the variation of the designer's name that is embodied in the account handle is made still clearer by Section 10B of the contract, which grants plaintiff the exclusive right to register and use trade and service marks in the designer's name and derivatives thereof, and unambiguously provides that plaintiff cannot make commercial use of marks that JLM has registered, the designer's name, or any confusingly similar marks. So the court's like, no, the contract says what it says. Let's see what JLM had to say about this on social media. And then we're going to go to see what Miss Haley Page had. Now, remember, the court's ruling, which we will timestamp, has barred her from using quite a lot of stuff until the end of this lawsuit. That doesn't mean that they can't still resolve this lawsuit. It doesn't mean that they can't narrow down what she can and can't do and carve out what her non-compete means. But JLM has won the big bulk of the legal battle here. Intellectual property is the cornerstone of every modern business, especially in the fashion industry. JLM takes these rights very seriously, which is why Ms. Gutman's employment agreement clearly and unambiguously, just like the court said, set out Ms. Gutman's why is that hard to say? Ms. Gutman's obligations, what rights were being acquired and what restrictions would be imposed on her, all of which she freely and knowingly agreed to. While JLM will never deny Ms. Gutman's talent, JLM rejects Ms. Gutman's accusations as well as her version of business ethics. Ms. Gutman testified in court that she does not believe that a material omission is a form of a lie. Oh, boom. That's a lot. JLM does not subscribe to that version of business ethics or how she is trying to mislead the public about the facts of this case or her own motivations. In her public statements, Ms. Gutman omits the overwhelming evidence submitted to the court that these social media accounts were an integral part of the Haley Page brand business and marketing strategy and were run as such, including admissions to that effect in her own emails. They're punching back because she's released 3 videos now about this, and we'll get into her video next. Ms. Gutman has also failed to disclose that she secretly licensed the Haley Page name to her fiance to license to third parties and asked to funnel payments through him. This was a clear attempt to avoid the explicit terms of her contract, which she knew did not permit those actions. Ms. Gutman says that followers should not be considered business assets, but that is exactly how she treated them when she sent analytics to get an influencer deal with Chosen Foods and used the Miss Haley Page account to promote Optimum Whey and salad dressing products for her own financial benefit. The JLM's not taking it sitting down. This is the first time we've really seen them directly speak up about this because she's released 3 videos tearfully saying that this company's big and bad and mean, and they are saying very clearly, but also there's more to that story. JLM does not subscribe to her version of business ethics where consumers and followers are misled and not given the facts. When the court considered all of the actual evidence and facts in this case, it rejected her argument. JLM strongly encourages anyone interested in this case to read the court's entire decision and reach their own conclusion. The entire court decision is linked in our bio, which Haley Page did with her side. She linked a Dropbox with her, and then they've linked it in the bio. She linked her response papers to them. So let's see what she had to say about this. And we're going to give some commentary as we talk through her latest video. And let me pull this up so you can hear it real quick, because otherwise you're not going to be able to hear it. Let's see how we can, let's pull this up. Let's pull this up so we can hear it. And we're going to do a little fair use commentary on what this is. Hopefully I'll pull this up correct so that you can hear it, because I'm learning how to do the things. It's like we're professionals. It's like we're professionals. It's like we're professionals. See, if I do it this way, I can share audio. Haha, thank you so much, StreamYard, for making it easy for me to figure out. All right, let's see what she has to say.
So
let me know if you can hear
waiting, we finally got the ruling. Sadly, the judge granted a preliminary injunction. I am, of course, disappointed, but I know that I put one heck of a truthful foot forward with a team that I respect so much. And for that reason, I am proud. So at this moment, JLM will keep control of my Instagram, TikTok, Pinterest accounts, the ones that I started and grew on my own accord.
I mean, I started and grew on my own accord kind of flies in the face of what the court ruled and what the court said and what the court determined, because the court said this is a business asset and you grew them together with your business. And that's what that is. I mean, that's exactly what it is. One can feel empathy and still acknowledge that the law is what the law is. So, okay, let's keep going. This is a great question. We're going to get to more questions at the end, but it totally caught my eye. If she changed her name after the non-compete period, yes. Which we've seen with makeup, we've seen with Kate Spade, we've seen with lots of others.
And I am still not allowed to use my own name in commerce or business, even outside of bridal.
And that's true for the period of the preliminary injunction. They're like, you can't go make brand deals on your name because your name is licensed and sold. You sold your name for money. You can't use your name to then be an influencer all up in the whoop-de-whoop, whatever. You can't do that.
So yeah, they are preventing me from making a living and doing what I love most.
Are they though? I mean, I understand that it feels like that, but it's clear that it's under her name.
So imagine if someone was to walk into your life tomorrow with a stack of papers and tell you whatever your life's work is, whatever your greatest passion in life is, you're done.
Imagine somebody walked into your life and handed you a stack of cash and said, hey, we want to build you. We want to make you famous. We want to pay you. We want to continue to pay you, and we want you to sell your name. She signed the contract, and she's still getting paid by them. These statements to me are PR. And her life's work will still go on. She can also change her brand name. She can't do it under the name she sold.
You're not allowed to do it anymore unless you do it on their terms and to enrich them. Well, I refuse to feel continually violated by this company. Just because you can use the law to take someone's social media account, someone's name, someone's ability to make a living, it doesn't mean you should.
And the things are her feelings. We don't argue with feelings up in here. She's feeling how she's feeling. But she signed the contract. So at this point, she is continuing, I think, to now say this company's big and bad. I get it. And that the conversation needs to be what's the bargaining power between companies and artists and the choices that are made. And we're seeing more and more musicians choose to be independent artists because of stuff like this. I want to know how much she got paid for these trademarks.
So this is where I draw a line in the sand. This is where I focus my best energy on building the new instead of fighting the old.
Good.
I have decided to take action on a couple of things.
That's exactly all you can do is say, okay, I signed this. In hindsight, I wouldn't have. Hey, artists, this is why I wouldn't have done this, but I did it. And now this is how I'm moving forward.
First, I have unfollowed all of my old social media accounts associated with JLM because I do not want anyone to be fooled or misled into believing that I have anything to do with it. They still.
Oh, I don't think anyone's confused at this point. I mean, maybe they are. Maybe people still don't know what's going on with this, but I feel like if you follow her closely, you know what the fuck is happening, but it's fair.
Aren't even allowing comments from people. I think they did this because they can't handle the public opinion.
Oh, they've turned off the comments. JLM has turned off the comments on all their social media accounts. And the thing is, I said it the last time I covered this case, JLM could very well win on the law and lose in the court of public opinion. That can very, very easily happen. But JLM also made it very clear, look, there are things that are disingenuous from her as well. So,
And there are probably still a lot of people who have no idea what has gone on and that I am not participating in these pages.
she has one social right now that is all that glitters on the gram. So she does have one new social, and she is going to have to rebrand herself under a different name. So that's what's going to have to happen.
Or those brands. Unfollowing is a small way for me to make a difference. It's difficult to believe that a social media relationship can just be deemed transferable to a business. That is just so wrong to me, and frankly, for lack of a better word, feels icky.
But icky, and this happens all the time with law, is like, oh, and this is why we talk about common sense critical thinking, because it feeling gross and it being legal are two totally different things. And often you can say, this shit seems wrong. We're going to talk about David Dobrik soon. This shit seems wrong, but the law says this. And that is something that is very frustrating for people, which is why we talk about these cases on this channel, to understand the difference between legal and illegal, and moral, justified, and what have you. There are legal and there's feelings. This case for me is not as offensive as other cases where artists have lost rights, because the contract was so fucking clear. It was very, very clear. And if she told the company that she had a lawyer review it, it's not their fault. It's not their fault. The bargaining position is clear when you are a starting designer and a large company is like, we want to bring you in. It's clear that you can either choose to take it or leave it. But she didn't even do that. Rounds of negotiation indicates that she had some bargaining power with them where they listened to her. And that means that they were working with her, and she just doesn't like it. It's also interesting to me that she's wearing all white. There was a defense attorney I used to work with that would do this. And in closing arguments, she would always wear white to make herself look like an angel of justice. And I always thought it was funny. So I would always come in wearing like all black. And I would be like, if we're going with a contrast, and I'm the big nasty prosecutor, fine, I'll wear all black. I'll play the role. I've got my pearls. I can clutch them when I'm offended about things you say in closing and go, ugh.
Fans, followers, and friends should not be considered business assets.
Now you know why JLM said, right, but you went ahead and also had brand deals. So if you're an influencer, having followers is a metric. You don't have to treat people that way, but it is a metric.
You deserve better than that. One thing I know is
sold
that
them
when
salad
I choose a
dressing
product from a business, I feel that their values, morals, how they treat people are just as important as the quality and authenticity of their designs.
True. Totally fair. Know the brands you're working with, know their morals and values, but them wanting to enforce a contract doesn't make them immoral in my position.
In my opinion, business ethics should extend far beyond what a contract says.
But also, business ethics is upholding your end of an agreement that wasn't unjust, wasn't coerced, wasn't illegal.
And should prioritize the beauty of creativity and show respect to the...
Oh, no. No, companies don't prioritize the beauty of creativity. Companies prioritize making money. See, you've got to follow the money. But also, the reason that she's fighting over her Instagram account is because it's got over 1 million followers. It's verified, and it's a valuable business commodity. Otherwise, just start a new account and don't fight over this one and be like, okay, I value creativity and ethics over all of this. I signed this. I regret it. This is why I regret it. So here's what I'm going to teach you about my mistakes. And I am starting over under a new name, under a new account, and I'm going to build it from scratch. No, she wants the million sub account back that she can do brand deals on because it's a valuable business commodity.
The community that has supported it. The fact that creatives are so easily subjected to this kind of struggle is shameful. And this is why I will not go crawl under a rock and be defeated. I will not be reduced by what has been taken from me.
I don't think anyone's asking her to be reduced. I think they're just asking her not to use the shit that she sold under her contract. I don't think they're trying to demean her as a person. This is the first time the company has spoken, other than, suing her, I suppose.
Me. Which brings me to my next step. And this is a big one. This is where I need your help.
How many times do you think she filmed this? Because this is a very contrived PR piece. It's a good PR piece. This is going to work. This is her connecting to her community, saying, who's coming with me? This is like her Jerry Maguire moment. The big bad company is trying to reduce me to ash, and I will not hide. They don't value beauty. Who's coming with me?
I may have lost this round in court, but the bigger story is about a girl you might know who is determined to dictate her own future. I refuse to be nameless and I refuse to be jobless. Since they have taken my name, I've decided to change it.
You sold your name. You sold your name. You sold your name. You sold your name for money, which is fine. No judgment. Sell whatever the fuck you want, but you sold it. They didn't take it.
Officially and professionally. A new name that will allow me to rise like the phoenix and build anew.
Put money in it now. Chat, comments. Does she change her name to Phoenix?
So today is the start of my search for a new name, and this community of creativity right here is the best possible place I could go to for help.
She's crowdsourcing a new name, which again is going to build that parasocial relationship with the community that loves her, because they are going to help her rebuild. We are going to rebuild stronger. Does she change her name to Phoenix? I want to know.
Will you help me pick?
Should we try to get Aphrodite and Bea Lucille to do a reading on this? What is she changing her name to?
A new professional name. A name needs to be positive and filled with light. Maybe a little feisty.
Light Phoenix.
And very authentic. It needs to feel like who I am today and the person I want to become. And just to give you some parameters, and
I want her to change her name to Phoenix and then have trademark issues with like the city of Phoenix. No, I'm kidding. I'm kidding. I'm kidding.
Helping me decide. It has to be brand new. It can't be based off my birth name or...
Right? It can't be based off your birth name because you sold your birth name. It has to be brand new. It can't be a, shall I say, derivative.
anything I've done with JLM.
I feel like it's a competition, like a design competition.
They are a part of my past, and this is my future. Names are powerful, but they can be easily diminished if the authenticity has been tampered with or jeopardized. If you have suffered, if you are hurting, one way to move forward is to give your life a new meaning and a new direction.
You know, she's going to go on Name Checker and make sure the URL is available before she decides to change her name. She's not wearing pink.
That is grounded in tomorrow. And that is what I hope to achieve with a new name. If there's any part of you that relates to this, any part of you that wants to stand up for others, please share this video. Please let people know that it is okay to push back. It is okay to pivot. It is okay to plot twist, because what is wrong is wrong. And I will choose.
Plot twist. They paid you. Here's the thing that protects her in all of this is that the company, because again, it's protected business information, the company has not shared how much money she received because all of the financials are redacted out of this case. Because I imagine that if it was released, how much she sold this for, people would have a much different feeling about it. So,
faith, love, and this community of creativity over profits and a court ruling every single day of
you're fighting in court for your account back because it's a valuable business commodity. That's a nope for me.
the week. So I'm taking any and all suggestions below. And thank you so much for joining me and for your continued
Oh, we binged. We're at
unwavering
89.4.
encouragement and support.
I understand the emotion behind this. I understand the regret. But the contract is not slimy and ambiguous. She doesn't like the terms now. There is a difference between not liking the terms now and not knowing what you're getting yourself in for. Did I just segue? Holy shit, that was a real, actual segue to the David Dobrik case. Look, regretting what you've chosen, but actually choosing it is different than saying yes to something and being served up with something fucking different. It is not the same situation. Y'all, we're over an hour into this. It's time to talk about David Dobrik. So let me close out some of these windows. By the way, do the YouTube things. This just binged. We're at 89.4 thousand subscribers. I love that y'all are here. Do the YouTube things. And I will be talking about this stuff more as it happens on social media because that's where I go talk about it. So Twitter, Instagram. I love seeing your guys' thoughts about this because this is like the JLM company is saying the law is this, we're following the law and protecting our business. And she's saying, but you're mean. These videos are very much on the line. She's saying, I don't like what you're doing. It's mean. They took the name. I mean, it depends. They did take the name, but it's because you contracted it. So it's like all of those close to the line. I imagine her PR team, and the reason I keep saying her PR team is because when you go to her Instagram, here, I'm just going to show you why I say what I say. We're going to just show you why I say the things I say. And of course I closed it out, which was silly of me. Thank you so much. Do it with me. Do it with me. Do pink hair with me. I love that. I love it. So all that glitters. Of course it's good. Okay, there we go. Also verified, by the way, and growing. Her contact information at digitalstrategies.org is a PR company. So for PR info and requests, we know she's working with PR. There's nothing wrong with working with PR. Working with PR as an influencer is probably a very smart thing to do. PR is great, but you can tell it's PR and that's okay. But that's also why I think she is going to not step into that territory of defamatory statements. It is going to be very carefully crafted to say what she needs to say without it crossing that line. So speaking of crossing lines, let's talk about David Dobrik, Jason Nash, and their friend Seth. I have a lot of thoughts. I have some feelings. And then we also have some, law. And those are all different things. If you're not familiar with who the fuck David Dobrik is, I don't know what to tell you. I don't watch the Vlog Squad. I don't watch his content. It seems like content made for teenagers because it's like, kind of jokey, pranky. It just reminds me of Jackass, but like less authentic to me. So David Dobrik and the Vlog Squad are fairly large YouTubers. It seems like they have a rotating cast of characters. Gabby Hanna used to be part of the Vlog Squad. Trisha Paytas was tangentially part of the Vlog Squad. These were people that came over from Vine when Vine was like, bye. So people who were used to making short content, then trying to extend that content and Vlogging your friends is one way to do that in an easy way. So they are, I don't know, pranksters. Is that how we would describe the vlog squad? David Dobrik also like gives away cars and shit. I don't know. As I said, I don't watch the Vlog Squad, not hugely familiar with them, became more familiar with them through Trisha Paytas's content about them, through some of Gabby Hanna's content about them, but not really through watching them. In my conversation of this topic, I am not here to besmirch, blame, shame anyone. We're going to talk about the actions that we've seen on video, the statements people have made, and what the law says about them, and what I think might happen going forward. People's experiences are their own. When people have experiences, what we're not going to do is say, but that's not your experience. No, that doesn't get us anywhere. If we're not in court. We're talking about, can this even go to court? Is this going to court? Because I'm seeing a lot of people saying things like, from Keemstar saying David Dobrik's innocent to others saying David Dobrik should be in jail. Well, those are two extremes of a position. And I think innocent is a very strong word. I also think jail is a very strong word. And I hate seeing people throw around, you should go to jail. That's not how that works. And I feel like maybe it's helpful to just briefly talk about how the criminal justice system does work, particularly in California where the Vlog Squad films, because I was a California deputy district attorney for over 10 years. And after health issues and burnout, decided to do legal consulting instead. Why? It's more fun. I loved being a DA, but having police protection in your house is, stressful. It's just stressful. And I don't always like that kind of stress. So after that, I got to do this. And now I get to take my experience as a DA who's done the things, sitting down going, this is how that works. Criminal law kind of 101. A thing has to happen that may be a crime. Once the thing happens that may be a crime, if a police officer sees it, they can arrest the person who's doing the thing. Like, oh, I'm watching you smash into a car window with a crowbar and you don't have keys for that car and it doesn't seem to belong to you. We can arrest you for that. Or someone sees the crime and calls the police and the police show up and they say, that person just did this thing. This thing seems to be a crime. Then you can arrest them. Or someone could call the police later and say, hey, this thing happened. I think it's a crime, and the police will take a report and start an investigation and maybe then put out a warrant to arrest the person who did the thing down the road if they can determine who the person is that did the thing. So kind of your entry points into criminal law. The police can see a crime happening. A crime can be contemporaneously reported. A crime can be later reported and investigated. In the case of some federal crimes, you could go on Real Housewives of New Jersey, floss a flashy lifestyle, rile the interest of the IRS, and end up in a full-ass criminal investigation that way. There are other ways, but those are the basics. Police see it happen, somebody reports it happening, investigation starts. So in this case, do we know if Seth has gone to the police? No, we don't. He has not said that. So no one's going to jail without a police report, ever, at all. And sometimes people get arrested for doing things and then they get out of jail because there's no follow-up on it. But the police would have to see you doing something. This is all years ago. This was all from the first incident that we're going to be really focusing on is from 2017. After someone's arrested, then in most areas, not all, New York's a little different, the police report goes to a filing deputy or a deputy district attorney who looks at the thing and goes, based on these facts as we have them, it seems that this crime has been committed, or that crime has been committed, or no crime has been committed, or I need more information. I can only speak of my experience as the LA County District Attorney's Office. I did filing work when I was recovering from back surgery. You get a police report, you talk to the police officer, you see if there's crimes there. You either file it and charge the person with the crimes and then arraign them, or you say, officer, I see what you've brought me. I'm going to need a whole lot more information. Here's a list. Come back when you've gathered those things for me. And then you send them on an investigatory scavenger hunt. And then they bring it back and you issue an arrest warrant for the person and say, okay, when you see this person, can you please arrest them and bring them to court? Because these are the things that they did. After that happens, after there is an arrest, they are told of the charges. That is the arraignment. Hey, person in court or on Zoom these days, you're being charged with these crimes. Your bail is being set or not set at this amount. You need to come back to court at this date. You either need to have an attorney or we can appoint you an attorney. If you're going to be arraigned, normally you would have an attorney there or you would have waived it. Have an attorney there when you get arraigned. And then a defense attorney will say things like, can we not set bail? Can we put over time to answer? Can we set this for preliminary hearing? Can we turn over discovery? All the things. Then it starts the court process with a preliminary hearing in California. In most cases, sometimes a grand jury. We're not going to tangent. This is not an entire semester of criminal law or criminal procedure, but a preliminary hearing, preliminary evidence is presented. Sometimes witnesses, sometimes police officers, testimonial evidence. And then the person who's in custody or out of custody is held over for trial. Hey, there's enough evidence to believe you're the person who did the things. Those things are crimes. They were done here. There's no statute of limitations issues. We will set this for trial. And then negotiations happen, which can happen after arraignment, before arraignment, and all that stuff too. But negotiations happen, discovery happens, things get set for trial, and then, they go to trial. And then after trial, if you're convicted, the judge sentences you. If you are not convicted, you get out. And that is what that is. That is the very, very brief summation of the criminal justice system, particularly as it plays out in California. So, has anything been reported in this case? No. What happened in this case? Well, David Dobrik does pranky type vlogs. There's video of him doing a prank on Seth. He tells Seth that Seth is going to kiss a woman. Okay, Seth is going to kiss a woman. She's going to be in a mask. This is part of the bit. This is part of the thing. She's going to be in a mask. He's going to make out with her. Great. Well, they decided to not put said female in the mask. Seth was like, okay, we'll do this kissing prank. Okay, we didn't put the female in the mask. They put Jason Nash in the mask instead. And Seth kissed Jason Nash. Okay. They take the mask off. Seth is shocked. There's then a podcast where Jason and David are laughing about it. I'll link it. There's a clip of it. Insider linked it, and other channels have talked about the clip of them saying, he didn't know about it. We didn't tell him it was going to be Jason in the mask, blah, 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 blah. For me, it does not matter that the genders in this don't matter. The gender in this don't matter at all. Because if it was for this part, the gender of Seth matters, I think, in how he's being treated in the public. But we'll get to that. Genders don't matter because if it had been a different female, there's still no consent to kissing that particular female. So the no consent doesn't matter that the genders were changed. It's no consent because he said, okay, I'll do this bit. I'll kiss this person. And then the person was switched. That's not consent. Is that an assault? Let's talk about it. In California, for there to be an assault from a criminal standpoint, there has to be sexual intent. And that is where I think it would be very hard for a prosecutor to stand up and prove beyond a reasonable doubt there is sexual intent here. That doesn't mean it's not wrong. That doesn't mean it can't be filed civilly. And we'll talk about civil. But does that mean that this particular incident that's on video is an assault that can be prosecuted? Not really. Why? Because when you look at the video, I think it's very clear that they're intending to humiliate, to embarrass, and to belittle him. That's all bad shit. But that's not what the sexual assault laws say. Could it be an assault? Yes, an assault is an unwanted touching. A criminal misdemeanor assault, maybe. But when we talk about sexual assault, there has to be touching of intimate parts. The mouth does not count. And there has to be sexual intent, doing it for a sexual purpose. I think a prosecutor would have a very, very hard time standing up in court looking at a jury saying, this was for a sexual purpose. No, it was for harassment. It was for embarrassment. It was for humiliation. Those things don't count under the sexual assault laws. Does it count under assault? Is it an unwanted touching? Yeah, it's an unwanted touching. How would that play out in front of a jury? It would be difficult. But in the world of civil liability, the rules are different. And we can talk about the rules in civil. So when people are saying, is this a sexual assault? The victim says he did not consent and says he consented to a person, and then that person was switched. He was humiliated, mocked, embarrassed, and traumatized. That's an assault. Does that mean it can be prosecuted as such? Not necessarily. I just think that the way that the law is written in California bars it from actually being able to say, hey, this is a sexual assault. And is it worth going after the misdemeanor assault? Well, the misdemeanor assault statute of limitations is a year, and that's already run. So this becomes difficult in the criminal context. It doesn't mean the behavior is okay. It doesn't mean that it's not gross. It means that this is something that a prosecutor would look at and go, how do I stand up and look at a jury and say this was for sexual intent? Because when you watch the videos and when you watch what David Dobrik and Jason Nash said on video afterwards, it's gross, but it's clear that it was purposeful to humiliate and embarrass. And here's the thing I don't like what I'm seeing is, especially when it came to Scotty, whatever the fuck his name is, his video. Well, he was joking along afterwards. He was doing this afterwards. The way people behave after something shocking and uncalled for happens is not how we judge the thing that happened. We're going to talk about trauma, assault right now. The way people respond afterwards does not indicate the thing that happened to them. It does not change the thing that happened to them. It does not diminish the thing that happened to them. People respond to traumatizing situations in a very, very wide varieties of ways. I think after everything I've watched that what was going on in the Vlog Squad is a hostile work environment, and we'll talk about that in a minute. But when you have someone in a position of power and they do something that pushes a boundary, humiliates, assaults, or otherwise traumatizes someone, the someone who is not in a position of power, their actions afterwards are generally not what one would expect. Well, one would expect from what? People who have lived through trauma, who have experienced trauma, who have friends who have experienced trauma, will look at that and go, well, yeah, people freeze afterwards. People try to go along to get along afterwards. People don't even know how bad what happened to them was until years later. It's why the statute of limitations on sexual assault in California changed, because it can take so long to unpack what happened to you, because gaslighting is real, because power dynamics are real, because freezing and being embarrassed is real. And I think that that is real for all victims of sexual assault, but our society makes this very difficult for male victims of sexual assault because it's a joke, because you should just man up, because it's no big deal, because why are you being so sensitive? Because you put yourself in that situation, because you said it was okay to do the prank and then they switched it on you, but you said it was okay. Because you went out to dinner with someone, because you'd had sex with them before. Yes, we're now extending the way I'm talking about it. Just because you had sex with somebody before doesn't mean they can't rape you. Just because you are in a relationship to somebody doesn't mean there doesn't still have to be consent. It's not okay. Just because you went out to dinner doesn't mean they can touch you in a way you don't want to be touched. It's not okay. Just because you work for them doesn't mean that they can abuse you in the workplace. And I think that the Vlog Squad is a workplace. Now, we've seen the conversations on the H3 podcast and other places where it's like, oh, but if this was a movie set, you would be cool with it, from David Dobrik and others. Oh, but if this was a movie set. Look, if it was a movie set, guess what? You can still be assaulted on a movie set when you've gone beyond consent. You can say, I consent to us making out, I consent to us doing this, I consent to us doing that, but now I've asked you to stop, and that's not continuing. Also, consent doesn't transfer to a different person. So swapping out the person behind the mask doesn't swap out the consent. That's not consent. That's not how that works. But because the purpose might not be a sexual gratification, the laws don't fit in criminal law. It doesn't mean it doesn't fit in civil law. And I think that this is more of a hostile workplace environment than it is a criminal case. But on a movie set, there are rules, there are regulations, there are lawyers, lots of fucking lawyers. And there is a ongoing discussion of, this is what you're agreeing to. This is what's allowed to be shown. This is what we're doing. It's very specifically lined out, where I don't think that that's the case with the Vlog Squad. We have not seen that put out in public. So do I think that the behavior is gross? Yes. Do I think that the Vlog Squad is like, well, if you were an actor, you'd be cool with it? No. If you were an actor, you would be sitting at a table and have a ton of conversation about exactly what was going to happen, exactly how it was going to be choreographed. What you wouldn't have is people being switched out. That's where we get into the conversation about whether this is civil. And here's what I think about the Vlog Squad as a work environment. I've looked at quite a lot of the information surrounding this, and I looked at that Scotty, whatever his name is, video that just shamed Seth. It's like, well, afterwards he seemed fine. Look. The psychology behind trauma and assault is specific. If there was a criminal case, even if there was a civil case, you would have experts explaining this is how people freeze afterwards. Some people fight, some people freeze, some people disassociate. There's no right or wrong. There just is human reactions. And human reactions of self-preservation are not to be judged, because human reactions of self-preservation vary. But also it's for a longer conversation of how was somebody left feeling about it, and did they consent to it? And with regard to the first incident, that the kiss where they swapped out the individuals, there doesn't appear to have been consent to that. The fact that then down the road, Seth didn't just quit the Vlog Squad and leave does not diminish the first incident. It doesn't change it. That again indicates to me that this was a hostile work environment where people wanted to please David Dobrik because they wanted to be on YouTube. They wanted videos that got 10,000 views, and they were pushing their own boundaries because David was encouraging them to push their own boundaries. And it seemed clear from those who have spoken out about the Vlog Squad that the second you said this is a boundary, David was like, okay, goodbye. Now, my question is, under California law, and this is what I was thinking about yesterday and today with this, the rules for independent contractors have changed. David Dobrik is a media company, and these are all individuals creating content. And if that's true, are they employees? And if they are employees, which I suspect they might be based on California's Dynamax decision, because it sure seems like they're all employees, then this is a hostile work environment where you feel like you can't report mistreatment to management because management will be like, oh, you don't like this? Get the fuck out. You can't do your work anymore. Also, are they paying the Vlog Squad like W-2 employees? Like, I wonder if eventually the state of California is going to be like, are there employment law violations here? Because there sure might be. Because it definitely seems like this is an employment situation. This is not a friend group. This is a business for David. Because your friends don't do this to you. Your friends don't make me feel like you can't come to them when you're uncomfortable at any point and say, this made me uncomfortable. Please take it down. And they don't take it down. I'm very, very curious how the Vlog Squad was paid for their work, if they were paid for their work, because they're creating content for David. I wonder when the state of California is going to start looking at YouTubers and TikTokers and be like, you have to adhere to the same rules as the movie studio. Let's get you some legal on site and some work rules. And with SAG, the Screen Actors Guild, extending membership to YouTubers, to influencers and TikTokers, I wonder if regulation is going to come. But I, as a law clerk, and I worked as a research attorney, law clerk for civil judges before I became a district attorney. And workplace harassment was one of the most common things that I dealt with. And this power dynamic between employer-employee, especially in the entertainment industry, where you will get blackballed if you are difficult, is so disturbing. It's where we saw the entire Me Too movement of people saying this happens in entertainment. That's what we're seeing in the Vlog Squad. The Vlog Squad is having its own Me Too movement of this is the way we were mistreated. And we can't say anything because of the power dynamic. So it's very interesting to me to see if this will be considered a workplace, if this is something that will actually be looked into. It might not be, it might. But David Dobrik's a media company. So the people in his media are employees. Just like when we talk about Kanye West Sunday service, all the other singers and dancers and everybody that showed up were employees under the law because California independent contractor law changed. And you can't just be running around California with people working in your business who aren't getting paid, aren't working. Clout is not a form of payment. Exposure is not a form of payment. Exposure doesn't pay your bills. And it seems to me that when David Dobrik gets called out for stuff like this, he tries to throw money at the problem, which also isn't a good fix. I think that we have a workplace situation here. I feel badly for the members of the Vlog Squad, but at the end of the day, do I think that David Dobrik did something illegal in a criminal law context? No. Do I think he facilitated a hostile work environment for those in the Vlog Squad? Absolutely. Do I think he continues to profit off of a hostile work environment and that violates potentially, because we don't know the contracts there, but potentially violates employment laws? Yeah, based on what we've seen people come forward with. And when we talk about the statement that came out, and other channels have covered it, is it Scotty Sire, have covered his statement, have covered what he said about this. Scotty Sire just blamed Seth for being involved in it. It's like, oh, you wanted to be involved. Oh, you wanted to film. Oh, you wanted it. You wanted it. You wanted it. No, it's called rape culture for a reason. Pushing people's boundaries because you are in a position of power is not okay. And the laws don't always fit squarely with that, but it's not okay. Now, with the Haley Page case, she was in a better bargaining position. There was a clear contract. Expectations were clear. She was paid up front. She had the ability to have an attorney review it. She said that she had. That's different than what I imagine goes on with the Vlog Squad based on what everybody has shared of their experiences, which is just like, if you want to be in the Vlog Squad, this is what you do. Do what David wants you to do. Do how David wants you to do. And that's the hostile environment, the pushing and the pushing and the pushing. And the people who are willing to push their own boundaries to please someone because of that position of power is exactly what we saw in the Hollywood Me Too issues. People pushing the boundaries because they had a position of power. So let's talk about the Scotty Sire video. The Scotty Sire video is exactly what you expect people to view sexual assault victims as. If you're not sure how sexual assault victims are treated by juries and by the public in general, the Scotty Sire video breaks down the difficulty in overcoming what's happened to them that sexual assault victims face. It's all of the things in there. Well, then he shouldn't have done this after. He shouldn't have said this. He was laughing. He thought it was funny. It was everything wrong with not understanding how trauma works, not understanding how trauma responses work, and not understanding that just because Seth could have agreed to a similar stunt down the road. It doesn't make the first instant where there was no consent any less of an instant. It doesn't make it any less of an assault. He did not consent to that touching. It doesn't matter if he consented to later touchings down the road. It does not matter. Just like you can consent to a touching at the beginning of a relationship and then say, I don't want you touching me anymore. The consent doesn't carry over. It doesn't extend. So again, just because I think that there are limitations to what is criminal in this, it doesn't mean that there aren't problems with this. But Scotty Sire's video, if you just watched it and went, fuck you, Scotty Sire, this is gross, I understand. But also know that what he shared is how a lot of people think. And if there's anything good to come out of that, at least it's a conversation to show how people treat victims of assault and sexual assault. At least it's a conversation to say male victims of sexual assault have a very hard time coming forward because of this. Female victims of sexual assault have a very hard time coming forward because of this. Trans victims of sexual assault have a very, very, very hard time coming forward because of this. When people share their experiences, listen to them. Listen to them. Hear their experiences. What happened to Seth was a non-consensual touching. It's not okay. Does it rise to the level of where our criminal laws are? I don't think so. Is it a problem? Yes. Is it a hostile work environment? Yes. I keep repeating myself. So Scotty Sire apparently apologized on a notes app. Today? Yesterday? Was that yesterday? Hi again. First of all, I would like to apologize to anyone who feels. Okay, well, that's not you apologizing for your behavior. That's you saying that their feelings are wrong. I would like to apologize to anyone who feels as though I disrespected or invalidated their story. That was never my intent. Yeah, because you don't know. And when you talk about things you don't know. And then you do shit that's harmful. Yes, belittles and I think non-binary victims of sexual assault would have a very, very difficult time along with the trans community of trying to explain and trying to be taken compassionately by police and sometimes by prosecutors. I thank you. I let my emotion get the better of me. Scotty Sire did not watch my video where we talked about critical thinking. We talked about the feelings, and then we talked about the thinking, and then we talked about how to process these things. Clearly. Also doesn't capitalize anything. I let my emotion get the better of me, and I chose my approach and many of my words poorly. The thing is, though, you still feel the way that you feel. He still feels the way that he feels. He still feels that because Seth didn't punch somebody in the face and go running out, that the thing that happened didn't happen. And Seth explained that on the H3H3 podcast. He said, what am I going to do? If I freak out, I'm on video and I'm the angry black dude. And if I don't freak out, then it's like, oh, well, then clearly it's no big deal. Ha, ha, ha. What do you do? And he's not wrong. You didn't choose your words poorly. You think that sexual assault victims' behavior after they're assaulted matters and invalidates because you don't understand. I'm sorry that you're mad. about how I perceive the situation. Anyway, I chose to make the video and share my opinion. Why? Why, though? Why did you choose to make the video and share your opinion on someone else's experience that you weren't there for and is not related to you? I expected it to be analyzed and picked apart, but I did not expect it to hurt so many people. Right. Do you know people who have been sexually assaulted? Have you had those honest and open conversations? Because I'm feeling like, nah. So I made the decision to remove the video from my channel. I didn't expect so many of you to be hurt that I told you that your experiences aren't valid, because if you didn't act the way I expected you to act after your experience, it means your experience didn't happen because you didn't act right. No. Nope. That's not it. That's not it. But at least we can have a conversation about what we've seen. The whole thing play out on social media. We've seen the incident happen. It's on video. We've seen Seth's response to it in the moment, and we've seen his later reflection on it after he's unpacked what happened to him and how it made him feel. We've seen Jason Nash and David Dobrik's response to it, saying that their intent was to humiliate him and that he wouldn't be able to talk about this to his friends for 5 years on. Ha ha ha. There's clips of that podcast. We've seen this happen. Seth chose to share what happened to him in a time when he felt safe enough to do so. Oftentimes, that is years and years and years later for assault victims. Our brains try to protect us from the horrible shit that happens to us, which makes it very hard to understand all of it. So, for someone to come out and say, well, you acted this way, so I discount your feelings, helps everyone who doesn't understand that perspective see it. Creepshow Art just recently did a video. I'm going to pull up her channel so I don't get it wrong. And I was finding a lot of frustration with this too. And she was talking about a Black creator here on YouTube who was receiving, and on Instagram, receiving horrible racist comments and backlash. And then shared about it. It's Thuman. And this video by Creepshow, if you want to see what Thuman has been experiencing, she has videos on it. I would go to Thuman's channel and Creepshow's channel, go to her Instagram. I've tweeted about it too. But Thuman shared her experience about the disgusting racism she was experiencing on her channel. And I think it's so important that she share it, because those of us that don't experience hate in that way can't fathom that others are doing this to someone, because it's not our experience and we don't know. You can kind of go, yeah, I understand that this exists, but you don't see it until someone is brave enough to share their experience. Thuman shared her experience and almost lost her Instagram account for sharing the racism that she was experiencing personally. And I shared one of her tweets where she was breaking it down. Let's just go to her Twitter account real quick. I shared one of her tweets where she was breaking it down. And my tweet, look, I don't have a big Twitter account. I don't. I shared her tweet because I was so horrified by what she was experiencing, and seeing it is a way that we can understand where other people are coming from when they choose to share that with us. That tweet got absolutely throttled. I'm not even seeing it on my main page. That tweet got absolutely throttled by Twitter. It had 1/10 of the reach that my tweets normally get, and I don't have a big account. She almost lost her Instagram sharing about this. So a Black creator is sharing about the horrible things that are being said to her in DMs, about the disgusting racism she's experiencing, and the social media platforms throttled her ability to tell her story. This is the way that we learn, is when we hear what others are saying to us. And we don't always do it perfectly, but we can do nothing but listen with an open mind and try. Because if you don't experience hate and racial hate, it is hard for people to comprehend that humans still say this shit to other humans. It's not hard for Black creators to understand because these are the types of comments that they get. And a lot of them don't feel safe sharing it broadly. And that's okay. No one has to share their pain. But when they do, when creators share what they're being told, the platforms are then throttling it is part of the problem that I have with censorship on social media, because you lose the valuable learning with trying to protect the shit that's hateful. And that's why that's why I decided to talk about the David Dobrik story. One, I think there's a lot of misinformation about whether somebody's going to jail. And two, it's an example that is playing out in front of us of how people who have experienced sexual assault, particularly because there's still shame wrapped around it, though there shouldn't be, but there is shame and there's questioning. Seth shared his experience and we can hear it. He shared it. And then we can see the reaction. And you can know exactly why people are afraid to speak up, because they see those reactions in their own lives. What Scotty Sire said is what people's parents say, what people's friends say, what uninformed commentators on the internet say. So that's where we're at with that. That's why I wanted to share it, because someone has shared their story and we've seen the outcropping. And it's a good opportunity for all of us to have real conversations about why this stuff is hard and to hopefully take the shame away from the victims. Because I don't think that perpetrators of sexual assault feel ashamed about the shit that they've done. I don't. It's the victims who are left questioning themselves. It's the victims who are left feeling ashamed and afraid. It's the victims that are left tearing themselves apart from the inside out. So talking about, is this clout chasing? Is this that? Is this? No. The first incident was a non-consensual touching, and because it was making out, it was of a sexual nature. So could there be a civil lawsuit? Yes. Do I think there's defamation going on? I would have to sit down and take a look at all of the statements going on, because I've been asked that a lot. It's like, well, is Scotty defaming Seth? Is Seth defaming Dobrik? Seth is sharing his experiences on video. He's saying it's non-consensual. I don't know what else there is. Consent later isn't consent for that. So that's what it is. And Elizabeth made a great point in the chat, and we're going to get to questions, so I stop ranting about this. But I think these are important topics, if hard and demonetized, to talk about, because when we understand, we can ask the right questions. Look, for us as a society, starting with, hey, we believe people's stories until we're shown otherwise, is a good starting point. Do people lie? Yes. Is that the majority of people? I don't think so. But a court of law is to decide where the truth is in the facts. In this case, there's video. And the video is what it is. So let's answer some questions. I know that was it's heavy. Let's answer some questions. I don't understand why there is a statute of limitations on assault, because there are statutes of limitations on almost all things in all states, except for murder, because the law considers at some point things are too old to be adequately litigated or prosecuted. It's changing. In California, it's now 10 years or 3 years from the discovery of the touching, whichever is later, which means if somebody has not realized that an assault was assaultive, they have 3 years from when they realized it, or 10 years, whichever is later. So the laws and the limitations are changing, but there are still statutes of limitations. Can you imagine it being on video on the internet forever? Like if my trauma was filmed, God forbid, but also posted on the internet. And that's part of this, is that the humiliation was intended. And that was the point of the whole gag, and viewed by over 10 million people. If you guys put questions, it helps. I'm also going to say that if you are here and you haven't found my channel before and you want to do the YouTube things, please do. We continue to have these conversations. And the reason that the videos take so long is because these are long conversations that have nuance and that need to be discussed. Question, is there any release that could absolve that kind of lack of consent? I don't think so. Could David Dobrik be making people sign away their consent? I don't think so. It would be very hard to say that you consent to a willful assault. And when you look at, movies, or when you look at other types of media production, you will see that the contracts are very specifically spelled out. It would be different if Seth had said, hey, I agree to kissing the girl in the mask, and then kissed the girl in the mask. It's different. But that trick and switch, you can't consent to being tricked. And that's the problem with pranks, is that a lot of times they go way too far. In Nashville, there was somebody who was doing a robbery prank, like, hey, it's so funny you're getting robbed. And they got shot and killed by the person who thought they were being robbed. I mean, prank content is problematic at all of it, because it creates that kind of toxic and hostile work environment of let's keep pushing it further and further for social media. And that's a whole nother conversation. But in that kind of thing, you would have to consent to all the parts of the prank, which makes them inauthentic, which I get from a filmmaker being like, well, we don't want them to know everything we're going to do. That's inauthentic. Well, then you run the risk of lawsuits and of these types of problems, because you can't just trick people into doing things that they haven't consented to doing. My alarm went off because I have to remember to wrap up. But I'm going to get to a few more questions. Thank you guys. I've seen a lot of you sharing your experiences. I haven't gotten to all of those. Thank you so much for sharing your experiences. Donald Duck, thank you for sharing that with the chat. And I'm not going to pull all of those up because you have, wait, what is this? Wait, I'm trying to find this one. Thank you for speaking for those who can't speak for themselves. A great conversation to have. Jamie, you're welcome. It's really why I became a district attorney. And I tell that story some. It's not all of my story to tell, because the reason I chose to become a district attorney involves other people's assaults and experiences. And it shook me to the point where I was like, I think I can do better. And I think I can lend my voice. And speaking up for victims of crime is something that is why I became a district attorney. One doesn't just become a district attorney. Well, I can't speak for everyone. I didn't become a district attorney because it's like, let's throw some people in jail. It was, let's speak up for those who have been harmed and can't come into court and speak for themselves. That's the point of being a district attorney for me. And it's hard when you look at things that are wrong and the law doesn't match, because you're like, I see that this is wrong, but the criminal legal system is not the right fit. The criminal legal system is structured around the defendant's constitutional rights, whether you like the defendant or don't. And we're going to talk about that as we get in, as the George Floyd trial gets kind of underway. We're going to get into that more as Officer Chauvin's on trial for murder. We're going to talk about the constitutional rights of the defendant, how victims are spoken for in court, and what goes on in a murder trial. But that's going to be a whole other day. Australia passed a law recently making it illegal for victims of sexual assault to publicly tell their stories. They face jail time and huge fines if they do. Oof. I don't know how that came about. I'd be very interesting how that came about. Ethan said it can be seen as racially motivated situation because of David and Jason's talking about the prank after. Could anything be done legally based on that? So being a racist is not illegal. It's disgusting. It's not illegal. Discriminating against somebody in the workplace based on race is illegal. So if the reason that Seth was unable to speak up in the workplace, if the Vlog Squad is a workplace, which is the analysis I'm going with, because to me, under the independent contractor test of California, the Vlog Squad feels like a work environment to me at a media company. But if the Vlog Squad is a workplace and Seth can't speak up because he feels like, I am the only Black person. If I speak up, I am going to no longer be here. I'm going to be replaced. I don't have a voice. Then yes, maybe, but that's in the civil workplace realm. I'm going to get to a few more questions. I'm trying, when you guys put question in front, oh, my chat just jumped. When you put question in front, it makes it a little easier for me to get to questions. And I am trying to do that. Question, could they have consented to kissing the person in the mask? Seth says he consented to kissing a female that was in the mask and the person was switched. If the person was switched and he only consented the person in the female in the mask, then no, that is not consent. So if he had consented to the female in the mask and it was the female in the mask, yes, there's consent. But that's not what happened. They switched the person in the mask. Therefore, there's no consent. And it seems very clear based on all of the videos afterwards that David Dobrik and Jason knew that that was the gag, that was the prank, and that's the part that caused the problems. So can Seth and Nick sue in civil for a hostile work environment? If it's considered a work environment, I think so. It's very hard. And there's a lot of evaluations that go into civil. But yeah, hostile work environments are a thing. Hostile work environments are civilly illegal. You can go after them in civil court for monetary damages. And so it would be a civil case where they would bring hostile work environment claims, among other things. They would probably bring all the mealtime, break times, adequate pay, things like that. I think there could be work-related things there. Again, if the Vlog Squad's considered a workplace, and the Vlog Squad would say, we're not a workplace, we're just a group of friends and we happen to have cameras. I think that there's a strong argument that it's a workplace. If David's intent and Jason's intent were different, could Jason be held accountable? David's intent is really irrelevant in the whole thing. And if I didn't make that clear, I totally apologize. So Amy, thank you for a great question. If David didn't do the thing, David was filming the thing, Jason's intent is what matters. And if Jason's intent were not to humiliate, if Jason's intent had or could be proven to have a more sexual characteristic to it, then yes, it would be a totally different situation. I have gone based on the interviews I've heard, the videos that I've seen. If there was something else that would prove that Jason's intent was different, then yes, it changes it for sure. Because Jason's intent as the person who's physically doing the action, as the person who's physically kissing Seth, that is the person whose intent matters, not Dobrik's. Do you think a jury would be more sympathetic if Seth was a woman? Juries aren't tremendously sympathetic to women either, unfortunately. So I don't know. I think it really depends on the jury. But when it comes to any type of assault by trick, it's a little bit different than some other fact scenarios. But I don't know. That was loud. Is it possible to lease your social media accounts to your employers whilst you work for them? Be better than selling your name? And almost anything can be contracted. It would just depend. It would really depend on the circumstance. But yeah, yes, it would be possible. It's also possible to be employed and have a private social media account that's your own. Question, I would like to know if an apology is an admission of guilt. It depends. My father, who was a lawyer, told me not to apologize to an accident because of this. It depends on the apology. And it depends. The problem with that is it really, really does depend. So yes, sometimes an apology can be seen as an admission of guilt. Yes, it can. Sometimes, not always. Would Seth have a better case for a civil lawsuit against Dobrik and Nash since they admitted that their intent was to humiliate, which did cause him harm? I think if Seth was going to sue anybody, it would be both Dobrik and Nash because they were both involved. And in the civil realm, both of them being involved is different because it was the setup involved them both. So yes, that's a good question. Thank you. I don't know anything about that, but I am trying to pump through as much stuff as we can, and the channel members do help me narrow down content, and I haven't asked in a while. So the channel members, as we add new cases to our roster, the channel members are going to be helping decide that. Is there a way that JLM could get back at HP for omitting the fact that she literally sold her name while she was pretending they took it? I mean, I think they released their statement. She's released statements. I don't think there's much else to be done. They're winning legally. And I think their statement is their statement. It would be very hard to say that mischaracterization is a gross mischaracterization, because if you look at just took, yeah, they took it because it was their property. So the way she's characterizing it, it would be tough for them to go after. Could they? Sure, they could. PR wise, should they? Nope. I think their PR statement was very good. And I think the harder they go after her as a company, it actually looks worse for them. I think they've really been very clear in their statements, but they also can't attack her. So that becomes more of a PR thing than a legal thing. If she keeps making statements, could that be added to the injunction? Possibly. It would have to be heard separately, though. Question, if I understand correctly, does this mean they would only be criminally liable if self-harmed himself in any way because of this? No. And criminal liability for self-harm is very, very difficult. And I hope that Seth does not at all. And I hope that him being heard helps him heal in his process. But no, that's a very different fact scenario. And that is still very, very difficult. Very, very difficult. And in some states, not prosecutable. Dinner's ready. Between the KJ lawsuit and now the slated, do you think government will soon focus on YouTubers and how they conduct business? I think there will definitely be an evaluation of how social media content is regulated at some point. So does JLM now own all of HP's personal photos on that Insta? Could she not repost like with Ariana Grande and the paparazzi? Yeah, they own what she created for Instagram based on this. Ruru, that's exactly right. I call it a prank because they called it a prank. That's how they couched it. But yes, agreed. Question, lightened fare. I may have bought an extra supernatural themed powder dip from Nails. Would you want it? I don't even know how to use dip powder, but of course, sure. Thank you. Possible, but hard. People aren't, the laws are trying to deal with what's going on social media. Thank you so much. The laws are trying to deal with it, and it's tough. I have, I'm sure David is operating as a full-ass business, which could be an issue for the employment stuff. I think the employment stuff is interesting. Do the U.S. have an employment court specifically for work issues? Oh, it's state by state because there are labor boards, but not for everything. So it is state by state. And we're seeing that in the Toddy Westbrook business partner lawsuit, where it's like, oh, there's a separate court, a separate track for business stuff. So it just depends. It's very specific to each state. Can there be a civil suit for Seth? Look, based on the facts that we have, yes, based on the facts that we have. If there are other facts that we are not aware of, that would go into this. So I think any attorney evaluating this would want to see if there's other content around this, other conversations around this, other video around this. There would be a lot of questions. Based on what we've had, the civil suit would make the most sense. So it can be a workplace without him making it an LLC. And making it an LLC doesn't necessarily make it a workplace, but it's definitely it's the behavior makes it a workplace. So when you evaluate employment law, and I'm going to have to wrap up here in just a second, when you evaluate employment law, you look at what actually is. And so LLC, not LLC is a factor, but what actually is that this is a media company. These people are part of the media. They're helping create the media. It feels like employees to me. Question, but not really. Jason mentioned in a podcast that he was touching and stuff in a sexual nature. It really does depend factually on what was said. So if he was saying, I was trying to make it sexy because then it would be funny, that's different than sexual desire defined by law. So it really, really depends. And I even think then, because we're not dealing with sexual gratification, sexual arousal, and we're not dealing with intimate parts, which is required by the law, it would still be hard to prosecute. I think it would be hard to prosecute. Is it considered a workplace? It can be. I heard somewhere that David doesn't pay his friends to appear in vlogs. I mean, it still can be a workplace just because you don't get paid. Then it's just a really illegally run workplace. How can Jason's intent be proven? Intent is proven through circumstantial evidence. So it depends what other circumstantial evidence there is. Oh, I have to go. Y'all, I'm sorry. I didn't get to all the questions. I will be back live on Friday. I think there's another filing due in the Toddy Westbrook case this week. I do not have a video going up tomorrow because I am running behind on content. So if new stuff comes up in the Toddy Westbrook case, we will ride. If you don't follow me on social media, that is where you will find out if we are riding. Text crew at textemily.com, Twitter at the Emily D. Baker, Instagram at the Emily D. Baker, and of course, be a subscriber here on the channel. And that's how you will know when I am going live. So I will talk to you all soon. Thank you so much. I appreciate all of you, and I will see you in the next one. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.